Okay, gentlemen, glad to have you with us today for this video. Have you been affected by having one of your children stolen from you after divorce? That's the topic for today's video. And if you're affected by this, stay with us, because coming right up, we're going to tell you about a father whose name is George, who has just lost his son for the second time, and he's doing everything he possibly can to reestablish his relationship with his son. We're going to tell you, first of all, about George's situation, what the 2 steps were, how he lost his son twice, what he is doing about it right now, and then at the conclusion of this video, we're going to outline 4 factors for George to consider in his case, and also those same 4 factors for you to consider if you've been through this same major crisis. And it is a crisis. So George's story and case history starts when his son was separated and divorced from the ex-spouse when his son was probably 4 or 5 years old. And of course, that was a big blow to the son. And the biggest blow to the son was what most of you who have been through this know, that the presumption was that the custody would go to the mother. And that is exactly what happened in George's case. And all that George was entitled to was some visits with his son. And that was devastating for the son, who had been very much involved with George's, his father's life. And the son wanted to continue that. But when these custody orders are handed down, they overwhelmingly go to the mother. And the father has very little chance. But so many fathers do not accept that, and nor should they. They continue to fight as much as they possibly can, but it is a very difficult battle. And of course, obviously, George lost considerable money to his lawyer trying to obtain custody, a futile battle, but he never gets that money back. So anyway, George did the best that he possibly could with his visitation time, and to maintain contact with his son and to allow his son to continue his experience, his very positive and exciting experience with his father. But a few years after the custody was awarded, the ex-spouse decided to pick up and leave with the son, take the son a 5-hour driving distance away from the home location, the city which is just north of Toronto in Canada, taking the child 5 hours away. How many of you have been through that? This is what is referred to in our legal system as mobility. And normally speaking, what the rule of thumb is that the parent who has custody also has mobility rights, the right to move wherever the heck they want, with total disregard for the child's desire to be with the other parent, with total disregard for the father's having any rights, and the father wanting to retain his relationship with his son. So she picked up and moved away a 5-hour driving distance. How is George ever supposed to maintain his relationship with his son now? So what does he do? What so many of you fathers out there, you fathers who are watching this video, you've done the same thing yourself. You hire a lawyer and start spending more thousands of dollars trying to protect the right of your son and your daughter to have a relationship with their dad. So, of course, as is true with most of these legal battles, they drag on and on and on. And what George did in the meantime, in the interim, he tried to travel that 5 hours, just an impossible task while he's got his employment just north of Toronto. To drive that kind of distance to see your son for what kind of a short period of time, it becomes prohibitive. Plus, your money is being drained at a very rapid rate. For any of you who have been paying lawyers' fees, you know how quickly your bank account drains down. Well, after multiple motion applications to try to force the mother to bring the child back to the home residence, the home area, the home city, the lawyer advised George that he needed more money to fight the legal battle. And you know what the story is from here. George's bank account by this time is down to zero. And so, needless to say, the lawyer informs him he will not act for him anymore. He can't continue to represent him because he's not going to get paid with that zero bank account. So the lawyer advised George that he should settle this case and let the mother get away with this and move 5 hours away from the home residence location just north of Toronto, Canada. Of course, George was upset, angry, not happy with it. But George is fully aware that he has no money. He barely had money to put food in his mouth, to pay for his residence, the rent for where he's staying. He has no money left. He's lost it all on these legal battles, trying to maintain contact with his son, who is by now probably 6 or 7, possibly 6 or 7, as the years roll by here. So his lawyer said he'll draft up a settlement agreement, and here are the terms which would drive any of you fathers out there crazy, and certainly were driving George crazy. But here they are, three conditions in the settlement agreement. 1, she will be allowed to move the 5 hours away. That's the part that just kills you. How can this possibly be the case? That's the status of our family law system today. Unlimited mobility for the custodial parent. And that's a separate video for a separate time on how we should deal with that politically to change that law, because that is totally outrageous that any parent should have the unlimited right to move the child anywhere and destroy the child's relationship with the other parent. Provision number 2, that there will be a schedule set up so that George can visit his son, as ludicrous as that is, 5 hours away. That's ludicrous. But that was the second term of the settlement agreement. And the term number 3 of the settlement, which was brought before a judge to be made into a court order after being signed by both parties. Provision number 3 was that the ex-spouse was to no longer in the future ever move the child another time. That was provision number 3. She was not to move the child away from this new city 5 hours away that George had to travel to. So that agreement was signed, of course, against George's wishes. But what choice does he have? Like all of you fathers who are watching and have gone through this same situation, what choice does he have? He had no choice. Talk about duress. That is signing an agreement under duress, if I ever heard of one. But as far as our laws are concerned and the courts are concerned, it's not viewed as duress because it fits in with our current family law situation. So George did the best that he could, trying to meet up to exercise his time with his child, which was 5 hours away, and then he decided this is an impossible situation. He's rapidly losing that relationship with his son, as many of you have been through. And he made an amazing decision. he decided to close up his business here north of Toronto. We tried to reestablish his business 5 hours away, relocate his home so he could reestablish that relationship with his son. You know, that in itself earns the highest respect from me personally and from every member that we have and every father we have in our organization, which is called KidsNeedTheirDads.com. And that is the organization that operates these videos, which we're glad that you're watching today. We have the greatest respect for George and every one of you fathers out there with the amazing sacrifices you have made in order to maintain that relationship with your children. So that's what George did. He packed up his business, his home, and relocated to accommodate this 5-hour move that the mother had undertaken. And of course, without George's permission and with no court permission either. She just got up and moved. So the court order, the agreement, this agreement was made into a court order, so that therefore it becomes law. And George relocated to where his son was and started to reestablish that relationship. And to the son's great pleasure, and to George's great pleasure also. He was now able to reestablish that relationship with his son despite the unbearable torture he had been put through. And with almost no money left in his bank, but he reestablished his business in the new location, started to earn money again, started to reestablish himself so he could rent a place for him to live, to bring his son to. Good for you, George. I'm sure George is going to be watching this video, and you are to be commended. You are a great, great father, as are so many dads who go through the same situation that you've been through. So that was when George's son may have been maybe 6 or 7. And by now, George, as of the present time, George's son is around 12 years old. But the zinger in all this, which some of you have been through, is that not that many months ago, the ex-spouse who was bound by this court order that she's not to, the third term was she's not to move again from that location. She picks up the son and this time moves 2,000 miles away. This, of course, as you can well understand, it drives George nuts because of the commitment that George has to his son and the commitment that so many of you dads who are there watching this today have to your children. We know all about it. And we want to hear from you down in the comments down below. Please tell us your situation, because what we do is future videos. We try to base those videos on some of the things that you tell us by putting your comments down below this video in the comment section. Okay, so don't forget to do that after the video is over, because we don't want you to miss the 4 steps that you and George can take to help you with your situation. So, of course, George hires another lawyer. And one amazing thing here was there was an application for a court order to force the ex-spouse to come back to 2,000 miles, bring the son back to the original home area above Toronto. It was unbelievable to me and to George and to most fathers that the judge did order the mother to come back to the original resident area, but just for the purpose of having a hearing as to whether the mother would be allowed to move permanently 2,000 miles away. So George instructed his lawyer, what I want you to do is I want you to, in responding here, I want you to apply to reverse custody so the son would come and live under the custody of George, his father. For those of you who have experience in family law, you know from the outset when you divorce or separate, the effort that a father has to put in to obtain custody of his child, the battle he has to fight is an uphill road, at least like that. For those of you who have not been through attempting to reverse custody, you may not be aware, but let me inform you right now, that type of a battle is uphill like that. And I really don't know if George fully appreciates how steep that road is, trying to reverse custody. But whatever George's wishes are, and as he proceeds, I assure you, George, I and the rest of our members are totally on your side, because what's happening to you is disgraceful, and it should not be allowed to happen to any father or any child who is losing his father. So anyway, that court case is in the works right now. The next hearing date is probably a few weeks down the road, and we will, for those of you who become involved with KidsNeedTheirDads.com, we will be keeping you updated through our newsletters as to George's progress, and if by some kind of a miracle he is successful in reversing custody, you will become aware of it. And momentarily, the title, which right now says, whoops, pointing my finger the wrong way, Stole Dad's Child, that title will be replaced with a title at the top of the page, which will give you the internet address where you can get in touch with us, so you can receive our newsletter, and so that you will be able to keep in touch with what is happening here with George's very important case, and so that you can learn about it yourself. But when we put the title at the top where you can get in touch with us, then we're going to start into the part of the video which outlines for you the 4 factors that George needs to look at, and that you may need to look at too if you're in the same situation that George is in right now. Okay, we're going to carry on right now with the 4 factors that we mentioned to you previously that George will have to consider for as his case evolves. He doesn't have to, but we recommend these 4 factors. And for any of you fathers out there who are going through the same situation, we'll outline those 4 factors for you too. 2 of those factors we're going to outline in this video, and the remaining 2 of those factors we're going to be outlining at some of the video meetings that we hold every Friday night, and that you will be given the opportunity to attend by way of video conferencing. And in the interim, while we're talking to you, you're certainly encouraged to write down the internet address that you see above there, which we told you we would give you, as to how you can get in touch with us, how you can become a member if you so wish, and how you can attend all of our meetings and receive our newsletters, and to keep in touch with what is happening with George. So while we're continuing, you can write down that internet address up there, so you have the chance to learn further about not only George's case, but the factors that may help you with your situation. So here are the 4 factors, and I'll read them off my list here so I don't forget any of them that we're going through with George. And with any of you fathers who can benefit from the same information. Factor number 1 that we're going to talk about right here in this video is, it's commonly referred to, and in some jurisdictions, it's actually ingrained in the law. It's called the friendly parent rule. So we're going to talk about the friendly parent rule. If you haven't heard about it, we'll tell you about it. And in those jurisdictions which do not have that written right into the statute, the spirit of the friendly parent rule is a part of almost every jurisdiction which deals with family law. Okay, so item number 2 that we're going to deal with is the best interest of the child. And most of you had heard that, and I think most of you can see how this applies to George's case, because there is no way that any lawyer or any judge can argue that it is in the best interest of George's son to be moved 2,000 miles away and rarely ever see his father again. That's disgusting, and it's not in the child's best interest. So that's factor number 2 that we're going to look at in this video today. And then in our next upcoming video meetings, we're going to look at factor number 3. And factor number 3 is called a parenting plan. And what we ask of all of our fellows, and it's very time consuming, it's a very big undertaking, but it's a significant factor in those fathers who are seeking custody or seeking to reverse custody, that uphill battle like that George is working on right now. Or if you're in a battle where you're trying to get custody, that's still an uphill battle like that. You need to be able to use every factor that you can to help weigh the court's decision in your favor, because you're up against a difficult battle. So that's item number 3. Factor number 3 is a parenting plan. And we want to, in our upcoming video meetings that you can become part of by going to that internet address, we talk about parenting plans. How do you put one together? How do you make it effective so that a judge and even the opposing lawyer have difficulty arguing that with these arrangements made for this child, how can you not rule that custody should be moved over to the father? But anyway, despite all these realities, still our family courts, as most of you know, they still give 85, 90% of custody awards always to the mother, despite what we're talking about here, right here. And then factor number 4 that we'll be dealing with again at some of our upcoming Friday night. Our video meetings are on Friday nights. And factor number 4 is self-representation. Can George represent himself? Can any of you represent yourselves? Again, we don't encourage you to do that. And at our next video meeting coming up, that we encourage you to attend with us, we do not push you into self-representation, handling your own case. We don't encourage you to do it, because why don't we encourage it? Because you're up against, again, a major uphill battle, major obstacles and opposition. You're dealing with a court system which is lawyer focused. You're dealing with the ex-spouse's lawyer who has been trained in law, who knows the law, has spent possibly years in the court system dealing with judges. He knows the system. And a lot of our fathers, they may be plumbers, they may be a car mechanic, they may be in the landscaping business. How can they possibly be put into an arena like this where they're presenting their case against people who it's been their whole life? Lawyers who have done nothing but argue these cases in court. Can you do it? Well, if you have been watching any of our videos, you will have seen that we provided to you 2 videos. 2 videos in which 2 mothers were put in jail. One, the first video we gave you, a mother was put in jail for 6 days for denying dad time with his children. And that gentleman, Wayne, from Hamilton, Canada, he represented himself. So can it be done? It is being done. The second video that we provided for you, if you haven't seen it already, I would suggest that you search for it in our channel, was a father who represented himself again. His name was Richard. And that ex-spouse was put in jail for 60 days. A 60-day sentence, was ordered to jail. So that, of the 4 factors that we want to teach you and teach George, we are not pushing or suggesting that George should represent himself, not at all. But is the point going to come again at which he has no more money left, and therefore he has to abandon his son? Is that what he's facing? We hope not. We really hope not. So anyway, we're going to go back to item number 1. That's factor number 1, and that is the friendly parent rule. It is not engraved in stone in all countries and all states and all provinces, but it's there in spirit, so you must pay attention to it. And this is what it means that a judge is supposed to, and in some jurisdictions required, to consider what the plans the father has to ensure that the mother, if he was given custody, to ensure that the mother will be able to maintain contact with the children. And the judge is supposed to consider what has the mother presented, what factors has she put together to show that she is going to make sure that the child maintains contact with the father. Well, in these mobility cases, it's pretty blatantly clear. I hope it's clear to some of the judges. It certainly is clear to everyone watching this video. If a mother is going to take the child 2,000 miles away, and worse than that, we have a gentleman who works for IBM. His daughter was taken from Canada to Australia. How is, on the basis of mobility, how in the heck is he supposed to maintain contact with his daughter? So anyway, if a judge can't see that moving the child 2,000 miles away is not describing a parent who meets the friendly parent rule, it's beyond comprehension how a judge cannot understand that. But in any event, it's what we were pointing out to George and to each one of you watching here. Keep that in mind. It's a very important factor. We want you to document it so you can present to the judge what your plans are, that the child would come into your custody. The mother would, of course, then, it's her choice if she wants to come back to the home city. But if she comes back to the home city, here are the plans that you're presenting to the judge, that you'll make sure that she has access, telephone calls, email contact, visitations on this schedule. And I'm going to tell you that if you present the friendly parent rule support to a court, that's one factor that you can implement, and George can implement to try to help your case. Factor number 2, and this is without any question, one of the most important factors that each one of you has to think about, because it is ingrained in our family law all around the world. It's that term referred to as the best interest of the child. And you have to build your case that you're presenting to the judge, or that your lawyer is hopefully is going to present powerfully to the judge on your behalf. But you have to argue and present the documents that show what is in the best interest of the child. And in reality, as much as you have to properly and forcefully prepare and show that this child was originally in the Toronto area, just north of Toronto, that child had a multitude of friends, and the child was uprooted and ripped away from those friends. The child's school was in the Toronto area. The child's doctor, who the child got used to, was in the Toronto area and got taken away from his doctor. The child's dentist was in the Toronto area, and the child was uprooted and taken away from his dentist. The church that the child went to was in the Toronto area, and all the people he knew at the church, he was ripped away from them. How in the name of God can anyone think that it is in the child's best interest to go through this ordeal? So for George and for every one of you, in your preparation of your case, don't focus, never focus on the harm that's being done to you, the father, despite the fact that we absolutely agree with you. You have been severely damaged, severely treated improperly. But think in terms of the judge. The judge is the person who will decide whether you get custody, or in George's case, whether custody will be reversed. The judge is supposed to be required by law, because the best interest of the child is written in law. And there are many components to that best interest of the child, which we're not going to go through today. We have a series coming up for all of you watching this video. We have a series coming up on custody for dads. And we're going to go through every one of those factors which are defined in law, which outline exactly what is meant in law by the best interest of the child. And every judge in every courthouse is supposed to comply with each of those factors. Whether they do or not, we're not going to, that's not we're not in control of that. And you're not in control of that. But what we have to do is we have to prepare all those facts, which some of which I just outlined for you, so that when they're presented to the judge, and in George's case, making it abundantly and overwhelmingly clear that it is not in the best interest of the child in this case to be ripped away from all the things that the child knows and is familiar with and taken away, first of all, 5 hours away. And just as the child starts to get settled down, ripped away again, and now taken 2,000 miles away. How can any judge in his right mind rule that that's good for the child? Clearly, it is not. However, we will keep you advised. And then in the next section of this video, we're going to tell you how factor number 3, which is a parenting plan, how we're going to outline that for those of you who attend our video meetings on Friday nights. And factor number 4, can you represent yourself? And can you do it successfully? We're going to cover those factors in the upcoming video meetings on Friday evenings. So we're going to come back momentarily and talk to you about some of the ways that you can implement these matters, and then make use of the address above there, which shows you how you can be in touch with us and learn more about, first of all, about George's progress. Is he going to win or lose? We certainly hope he wins. We hope that you win, because we're here making these videos to help you in every way we possibly can. Okay, now we're going to look at 3 factors to help you obtain more information in our upcoming videos. Item number 1, as we said earlier on in this video, go to the comments below this video and outline for us the nature of your problem, what difficulties you're facing, and what goal you're trying to achieve. One of the primary reasons for that, of course, is that we base our future videos on the problems that you are having, the issues that you want information on. If you don't leave us a comment down below in the section below this video, we don't know what your problem is. So that's item number 1. Be sure to leave a comment down below when this video is over. Factor number 2, as we've said already, and you can understand, we have a multitude of videos coming in the future that will be very helpful for you. So therefore, at the bottom of this video, click the subscribe button. Click the subscribe button and the notification bell. If you don't subscribe and you don't click the notification bell, you will not know when the next video is coming up. So be sure to do that. And factor number 3, which we've mentioned already, it's so important that you copy down that link above. And all of these 3 factors that we're bringing to your attention are, of course, tools and mechanisms to give you the opportunity to do everything you can, which you certainly are no doubt trying to do, to help move forward with your case and to protect the interest of your children and their opportunity to spend time with you and to have contact with you. And we'll say to you again what we've said several times before, that if you and we don't work together to implement these improvements for your children, they cannot do it for themselves. They depend on you. So let's get started right now. Thank you so much for watching.